Rule 130, Section 10. 3. Parol evidence. Parol evidence rule. Section 10. Evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, as between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. However, a party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts in issue in a verified pleading. A. An intrinsic ambiguity, mistake, or imperfection in the written agreement. B. The failure of the written agreement to express the true intent and agreement of the parties thereto. C. The validity of the written agreement. Or D. The existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. The term agreement includes wills. 4. Interpretation of documents. Section 11. Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise. Section 12. Instrument construed as to give effect to all provision. In the construction of an instrument, where there are several provisions or particulars, such a construction is, if possible, to be adopted as will give effect to all. Section 13. Interpretation according to intention, general and particular provision. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and particular provision are inconsistent, the latter is paramount to the former. So, a particular intent will control a general one that is inconsistent with it. Section 14. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the position of those whose language he or she is to interpret. Section 15. Peculiar signification of terms. The terms of a writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. Section 16. Written words control printed. When an instrument consists partly of written words and partly of printed form, and the two are inconsistent, the former controls the latter. Section 17. Expert and interpreters to be used in explaining certain writings. When the characters in which an instrument is written are difficult to decipher, or the language is not understood by the court, the evidence of persons skilled in deciphering the characters or who understand the language is admissible to declare the characters or the meaning of the language. Section 18. Of two construction which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he or she supposed the other understood it. And when different construction of a provisions are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. Section 19. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and the other against it, the former is to be adopted. Section 20. Interpretation according to usage. An instrument may be construed according to usage in order to determine its true character. Letter C. Testimonial evidence. 1. Qualification of witnesses. Section 21. Witnesses, their qualification. All persons who can perceive and perceiving can make known their perception to others may be witnesses. Again, all persons who can perceive and perceiving can make known their perception to others may be witnesses. Religious or political belief, interest in the outcome of the case or conviction of a crime unless otherwise provided by law shall not be a ground for disqualification. Section 22. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Section 23. Disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse, except in a civil case, by one against the other, or in a criminal case, for a crime committed by one against the other, or the latter's direct descendants or ascendants. Section 24. Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases. A. The husband and the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. B. An attorney or person reasonably believed by the client to be licensed to engage in the practice of law cannot, without the consent of the client, be examined as to any communication made by the client to him or her, or his or her advice given thereon in the course of or with a view to professional employment, nor can attorney's secretary, stenographer, or clerk, or other persons assisting the attorney be examined without the consent of the client and his or her employer concerning any fact, the knowledge of which has been acquired in such capacity except in the following cases. A1. Furtherance of crime or fraud. If the services or advice of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to the crime or fraud. 2. Claimants through same disease. Client. As to the communication relevant to an issue between parties who claim through the same deceased client, regardless of whether the claims are by testate or intestate or by inter vivos transaction. 3. Breach of duty by lawyer or client. As to a communication relevant to an issue or breach of duty by the lawyer to his or her client or by the client to his or her lawyer. 4. Document attested by the lawyer. As to a communication relevant to an issue concerning the attested document to which the lawyer is attesting witnesses. Or V. Joint clients. as to the communication relevant to a matter of common interest between two or more clients, if the communication was made by any of them to a lawyer retained or consulted in common, when offered in an action between any of the clients, unless they have expressly agreed otherwise. C. A physician, psychotherapist, or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot, in a civil case, without the consent of the patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including alcohol or drug addiction, between the patient or and his or her physician or psychotherapist. This privilege also applies to persons, including members of the patient's family, who have participated in the diagnosis or treatment of the patient under the direction of the physician or psychotherapist. A psychotherapist is a person licensed to practice medicine, engaged in the diagnosis or treatment of a mental or emotional condition, or B, a person licensed as psychologist by the government while similarly engaged. C, a minister, priest, or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession. D. A minister, priest, or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession made or any advice given by him or her in his or her professional character in the course or in the course of discipline enjoined by the church to which the minister or priest belongs. E. A public officer cannot be examined during or after his or her tenure as to communications made to him or her in official confidence when the court finds that the public interest would suffer by the disclosure. The communication shall remain privileged even in the hands of a third person who may have obtained the information, provided that the original parties to the communication took reasonable precaution to protect its confidentiality. 2. Testimonial privilege. Section 25. Parental and filial privilege. No person shall be compelled to testify against his or her parents, other direct descendants, children, or other direct descendants, except when such testimony is indispensable in a crime against that person, or by one parent against the other. Section 26. Privilege relating to trade secrets. A person cannot be compelled to testify about any trade secrets unless the non-disclosure will conceal fraud or otherwise work injustice. When disclosure is directed to the court, shall take such protective measure as to the interest of the owner of the trade secrets and of the parties and the furtherance of justice may require.